This is Michael Popok, Legal AF. If you thought the fighting would be done about Donald Trump losing, being on the losing end of Judge Engoron's decision to find him guilty of 6 more counts of fraud, disgorging up to $500 million, including interest from Donald Trump and others, and banning him from the industry, you'd be wrong. Because now Donald Trump's lawyers want to complain about the actual piece of paper that we call in the business the judgment. Now, let me unpack it and explain it on this hot take. When a trial judge, who is the trier of fact without a jury, makes his findings of fact and conclusions of law, it's generally in New York practice contained in a document we call a decision and order. We get, when you practice in New York, we get decisions and orders all the time from judges. That's what they call it. It's a decision and order. When a jury renders a decision, it's called a verdict. When a judge does it in New York, it's called a decision and order. It's also basically the judgment. When an entity other than a jury renders a result, it is called a judgment. When a jury does it, it's called a verdict, or at least what we call the petit jury, the jury underneath a grand jury. Judge, as we know, issued a 92-page bespoke, created it himself, decision and order, which had dozens and dozens of findings of fact, because he's the trier of fact, no jury, and conclusions of law, and then a remedy section related to disgorgement, injunctive relief, the establishment of a independent compliance director who will work with the already established independent monitor, and the expansion of the monitor's powers, the banning of Donald Trump from certain business activities in New York and being the head of a New York corporation, for instance, and those of his children. That's contained in the decision and order. The next step, and the way the judge the way the judge is always at the end of a trial, will then direct the clerk of the court, another functionary, civil servant within the criminal court system or the civil court system, to enter judgment. That's our phrase, term of art, enter judgment. And then it's up to the parties, or one party, to submit a proposed judgment. And it is that judgment, not the decision and order, it's the judgment that effectuates whatever's contained in the decision and order. In other words, you can't take a decision and order, hand it to a sheriff, and go tell him to levy or her to levy on property. Go seize Donald Trump's assets. Go seize Donald Trump's building, his boats, his yachts, his bank accounts, his money, his artwork, and so on. You can't do that with a decision and order. The sheriff will look at you and say, "What is this?" You say, I just won. He says, well, you may have won, but I need a piece of paper that's called a judgment. So go get me the judgment that puts into place, implements the decision and order. So the lawyers generally, although sometimes a judge will do it, never a clerk of the court, will actually draft a judgment. Now, the judgment should mirror the remedy section of the order. Right? It doesn't need to have findings of fact or conclusions of law. That's already been done in the decision and order. In fact, the judgment will incorporate by reference the decision and order. So it's already sort of there. But then there has to be an actual judgment that follows, in this case, New York law to a T with all the magic language in order for it to be enforceable. Has to have the debtor's address, and there's all sorts of rules under our civil code. We call it the CPLR in New York, that tells you what the judgment must contain in order for it to be effective. And if it doesn't have certain of that language and certain of that provisions, we call that a defective judgment, and it can be quashed or ignored. And if it's the basis to seize property, that can be overturned. So you want to have a judgment that complies with the law and complies with the decision and order. There's now a fight between, what else? Donald Trump's lawyers, led by, in this case, Cliff Robert, who worked with Alina Habba and Chris Keiss so well that they lost. And he doesn't like the judgment that the Attorney General submitted. Now, I look at that judgment, that draft that was submitted by the Attorney General comports with New York law to a T, checks all the boxes for the magic language and incantations that need to be on there in order for it to be valid under New York law and a line of cases related to judgments, and puts into place properly without, and crosses the I's and dots the T's, dots the I's and crosses the T's on the decision and order 92 pages of Judge Engoron. That's what a judgment's supposed to do. It's supposed to be several pages, incorporates the D and O, the decision and order, and there you're off and running. But no, Cliff Robert doesn't like it for Donald Trump. He wants a new proposed judgment. But we know what they're going to do. The reason he wants a new proposed judgment to submit to the judge, to settle the issue, so to speak, is because he wants to rewrite history and argue, I am sure, in reconsideration that the judge doesn't enter the judgment and that he enters a judgment that's in favor of Donald Trump. So he'll start jerking around with the numbers. They'll start jerking around with the findings. But that's not what the judge has already written a 92-page decision and order. You can ask for reconsideration, but you will lose. You can then take it up on appeal if you don't like the decision and order and the resulting judgment. You can take it up on appeal, which they're going to do. They just need to post their bond within, I think now we're down to 25 days. Has to be a substantial bond because he's not going to be able to get what's called a surety bond. He'll have to post a lot of cash for his bond, Donald Trump, because of his background and the finances. But the judgment is sort of a mechanical exercise that shouldn't need letter writing, huffing and puffing by Donald Trump's lawyers. As I count down to new fatherhood, the more I find myself wanting to be that much more intentional about the way I live, eat, and take care of my body. MeidasTouch is a company founded by Maria Shriver and her son Patrick Schwarzenegger with a simple mission: to create a conversation about brain health through food, education, and research. Maria's father suffered from Alzheimer's, and since then she and Patrick have dedicated themselves to finding ways to help other families dealing with this debilitating disease. MeidasTouch joined forces with the world's top scientists and functional nutritionists to go beyond your average protein bar. With 6 delicious flavors, each MeidasTouch bar has 12 grams of protein and is made with ingredients that support brain health like ashwagandha, lion's mane, collagen, and omega-3s. They also have a line of plant-based protein bars in 3 delicious flavors. But here's the best part to make you feel good. MeidasTouch donates a portion of all proceeds from your order to fund gender-based brain health research through the Women's Alzheimer's Movement. Why gender-based? 2/3 of all Alzheimer patients are women. MeidasTouch is working closely to close the gap between women and men's health research. The MeidasTouch bars are incredibly delicious. My favorite? Cookies and cream crunch. I have a MeidasTouch bar every morning before my workout, and it's the perfect way to kick off my day. If you want to find ways to give back to others and fuel your body and your brain, MeidasTouch bars are the perfect choice for you. Head to MeidasTouchLife.com/legalaf to save 20% off plus free shipping on your first 6-count trial pack. That's 20% off plus free shipping on your first 6-count trial pack at MoshLife.com/legalaf. Thank you, Mosh, for sponsoring this episode. Instead, we got a letter that is now in the public docket, which I'm going to read from now from Cliff Robert. And what it says, it's always high dudgeon and clutching of pearls when it comes to Donald Trump's lawyers, whether it's Alina Habba or in this case, Cliff Robert. Dear Justice Engoron, he writes as of today, we write on behalf of all defendants in response to the Attorney General's improper unilateral submission of a proposed judgment to the clerk at 5:21 p.m. Oh, this is breathless. Which incredibly states that it is on motion of Letitia James, Attorney General, but fails to provide any notice whatsoever, thereby depriving defendants of the opportunity to be heard. I mean, Cliff, heard about what? It is a mechanical exercise to draft it's a plain vanilla judgment that's supposed to reference the D&O and implement it. And that is the piece of paper that you take to the sheriff to execute on. The judgment, not the decision and order. And then he goes on to accuse Letitia James, what else, of violating the rules in the state of New York, which she has not, and says that they want additional time to, as they argue, defendants submit that the appropriate procedural mechanism for submitting a judgment to the clerk of the court is a directive to settle order, meaning the defendants and the plaintiff, in this case, New York Attorney General, have to propose either competing judgments or agree on the judgment language, submit that to the judge for approval, and then to the clerk. That is one way to do it, but it's not necessarily the exclusive way to do it. They want more time to submit a proposed judgment and a counter judgment to the clerk. And therefore, I love it. Should the court have any questions, please feel free to contact me. Here's what I think is going to happen. I don't think the judge needs either the Letitia James, New York Attorney General, nor Cliff Robert to draft an appropriate judgment. He's got a law clerk. In fact, he's got a principal law clerk. It's the one that Donald Trump continues to bash and claim to be a Democratic hack and the girlfriend of Chuck Schumer. She has a job to do. One of the jobs that she can do is help draft a judgment which properly effectuates the decision and order of the judge. He doesn't have to rely on submitted competing judgments. This is, again, a plain vanilla ministerial implementation of a decision and order. It should take all of, an hour to draft. And the judge, if I know the judge well, he'll be sending out an email soon that'll say something along the lines of, Mr. Robert, I did not say I'm going to be using or adopting the Attorney General's proposed judgment. I will be drafting my own judgment. If you'd like to send me some language that you'd like to see included in it, I will consider it. But then I will draft my judgment and send it to the clerk for execution. And then there will be a judgment out there from which you can appeal. That's what I think Judge Engoron's going to do, but we'll have to sit back and watch. What I love watching is the high wire act without a net of the lawyers for Donald Trump, like Alina Habba, Cliff Robert, and Chris Keiss, who's been strangely quiet lately. I think he's worried about his law license. In attacking Judge Engoron, but then in the same breath, asking him for favors and asking him for to bend over backwards to accommodate requests that no other defendant would ever get. Here's a newsflash for Cliff Robert, the principal law clerk, the person you said was co-judging the case, sitting next to the judge. She can draft the judgment and the judge can sign off on it and they can submit it to the clerk and they don't need anybody's input. It's not that hard. Like I said, it's a 60-minute project. So we're going to continue to follow the emails I know are going to be popping out from Judge Engoron because he likes to communicate with the lawyers by email. Or he's just going to have the principal law clerk draft the judgment, submit it to the clerk, put her stamp on it, and we're off and running, and let's get going on the execution of it. And if Donald Trump doesn't have the money to put up, then as Letitia James has said, and I've commented on another hot take, she can start seizing buildings and assets, executing on that very judgment and doing post-discovery depositions and another fact-finding to get to the bottom of Donald Trump's assets. Or she can just turn to the court-appointed monitor, Barbara Jones, former federal judge, and ask her for a list of assets and then execute on those. We'll follow it on the MeidasTouch network, where we don't blow smoke or sunshine. And on Legal AF, the title means just what you think, on Wednesdays and Saturdays at 8 p.m. Eastern Time. And on this network, 2 million strong, going to be 3 million by November 5th, and then on audio podcast platforms of your choice. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.